Welcome to this video series on addressing the dispute resolution challenges of Japanese companies doing business in ASEAN. This series is jointly produced by the ASEAN-Japan Center, the Singapore International Arbitration Center, and the Singapore International Mediation Center. In this episode, we'll be looking at the role that international dispute resolution plays in supporting cross-border commerce. My name is Michelle Sonnen, and I am the head of Northeast Asia at SIAC. I'm delighted to be joined by three experts in international dispute resolution. Mr. Lock V. Ming, Senior Counsel, the Deputy Chairman of SIMC, and Managing Director of LVM Law Chambers in Singapore. Mr. Tetsuo Kurita, with One Asia Lawyers based in Singapore. Mr. Teppei Mogi, of Oebashi LPC and Partners based in Osaka. Thank you for joining us today. We'll start with what may seem to be a basic question, but it's an important one to lay the groundwork for the rest of this video series. What dispute resolution options are available to companies that are conducting trade and investment overseas, and in particular for Japanese companies doing business in ASEAN?
Well, dispute resolution, like taxes, is an unavoidable and integral part of any business transaction or business relationship. It's something that parties may not like to talk about, at the start of a business relationship, but it's something that you would have to deal with because disputes, whether you like it or not, is very likely to rear its ugly head. And the better you are prepared to deal with it, the better the outcomes will be. Now, there are three main dispute resolution options which are available to parties, and that's litigation, arbitration, and mediation. Now, litigation is the dispute resolution process through the national courts of each country. And that's something that most of us are quite familiar with. Now, what is arbitration? Lay clients sometimes ask me, isn't arbitration the same as litigation? No, not quite. Arbitration essentially finds its basis in the consent of both parties. So both parties will have to agree to mediation, to arbitration, and they choose a person to decide the case between them. And this person is a privately appointed judge or equivalent of a judge, right? So he or she is going to decide on who wins or who loses, and that's in the arbitrator. The strong point of arbitration is that an award by the arbitrator would very easily be enforceable in two different countries, especially both countries are parties to the New York Convention. Now, the New York Convention is an international treaty that allows awards in member countries to be enforced in different countries throughout the world. Mediation is a process by which both parties come together and try to find a negotiated basis for an amicable settlement of their dispute. So it may not be that one party ends up the winner and one party ends up the loser. Hopefully, it will be a process which finds some sort of landing or conclusion at some point acceptable to both parties, and that both parties come away with something from the dispute. So that really is are the three main options available.
So a very important part of doing business overseas is maintaining relationships. How can parties maintain the goodwill that they have built with their overseas business partners, even when they have a dispute?
I'm helping many Japanese clients doing business in ASEAN jurisdictions. And I find one of the most key points to maintain good relationship is to understand counter culture and business customs, including which the counterparties laws coming from, especially from common law jurisdictions or civil law jurisdiction. And when helping our clients, most of the time, our clients find difficulties understanding the common law jurisdiction concept for Japanese client. Especially in Japan, where the civil law jurisdictions, it is very easy to understand the counterpart because we are coming from the same concept of the law. But if the counterpart is Singapore or Malaysia, those countries where common law jurisdiction, the law, legal system, legal framework, litigation system, all aspects very different in all aspects. Therefore, it is also more important to have somebody inside or externally to understand common law jurisdiction from the viewpoint of Japanese company.
What should Japanese companies doing business in ASEAN consider when they're choosing between these dispute resolution mechanisms?
One of the biggest advantage choosing arbitration or mediation is they can escape from the difficulties dealing in the local court in local language. And for instance, if having a litigation in Vietnamese court or Myanmar court, you have to deal with those legal issues in Vietnamese language or Myanmar language. On the other hand, if you can choose arbitration in English, you can deal with legal issue in English so that the both parties can understand and both parties can directly communicate in English. Or sometimes the agreements between Japanese related companies only, you can even agree arbitration or mediation in Japanese language so that they can speak and settle the case in Japanese language, which is more easy and familiar for Japanese companies. The second benefit could be they are also escape from the instability of the local court. For instance, if you may go to the court in developing countries, you may have to deal with some instability or bribery issue or those risks. You may want to avoid those situations. You can choose arbitration or mediation so that you may able to choose your arbitrator or your mediator so that you have more, you may have a more comfort settling or arbitrating the case.
First, I recommend to avoid litigation. Although Singapore, Japan, or some other country has very good court system, but it is not the case in all ASEAN countries. Even if they have some good system, we do not know the law of that country very well, especially procedural law. We do not know how the court works in that country. So unlike such litigation, in case of arbitration, there is an international practice for arbitration. So counsels know how the arbitration goes. And also one thing is good if it's being said that in case of arbitration, the parties can choose arbitrators. In case of 3 arbitrators, there is a chance for you to include an arbitrator who knows Japanese law and Japanese country, Japanese customs, and how business people think about in Japan. So that's good things. And even if one arbitrator case, you can rely on the, in that case, often if the parties cannot agree upon one arbitrator, party can ask arbitration institutes such as SIAC to appoint one arbitrator. And we can believe that such an institute can choose good independent arbitrator. That's one of the good things for arbitration. So I recommend arbitration first. And then, of course, the international mediation is another choice. Although I'm in charge of the International Mediation Center of Japan, but not only for that, I often recommend my clients to try mediation. Mediation does not take so much time, maybe 1 or 2 days, and does not cost so much. Then, in case of the arbitration, SIAC is one of the good choice. I think that in case of mediation, SIMC and GMIC, Japan International Mediation Center, is very good choice.
Clients sometimes ask me, what really is the main difference in the process between a mediation and an arbitration? Is it because In a mediation, parties come together in a more informal setting, and therefore they are less adversarial to each other and more friendly, and therefore they're able to reach a settlement easier. My answer to that is that it's not just the physical environment that a mediation process takes place in, but really also in the posture and the approach taken by the parties. Take, for instance, the mediator, as opposed to the arbitrator or the judge. The arbitrator or the judge sits in judgment, or is the person who makes the decision as to which party is right and which party is wrong. The mediator doesn't play that role. The mediator tries to find a position that's agreeable to both parties and to use that to find a basis for settlement. In a mediation process, plays a slightly different role at times, and that role is to find out whether there are shared interests or shared objectives of both parties, and try to find out what those shared interests are, and to see if they are big enough to form the basis upon which a negotiated settlement can take place. So when you have that approach, which itself translates into a certain positivity and constructiveness when you come to a mediation, it sets the scene and gives the impetus for parties to try to settle. And that's a big difference. So the UpMed Up is an initiative started and adopted by the Singapore International Mediation Centre, which effectively combines the strong points of both of these options. And it involves parties commencing arbitration where there is already a dispute, and then they exchange the initial sort of points of claim and defence with each other, so that both parties know the framework within which the disputes will be fought. And then at that still very early stage of the proceedings, the arbitrator then halts those proceedings, and parties then go off to mediation. And where, if you have a very skillful mediator and where the posture of both parties are positive, and are inclined towards giving a settlement a good chance, then and a settlement results, let's say, from the mediation process, parties then come back to record that settlement via a consent award, which can then be enforced if necessary via the New York Convention. And if parties do not successfully mediate through the mediation process, then they just come back again and continue the arbitration process. It's only a small detour. There won't be a great deal of delay. So it's easy to understand how this can really be an advantage for parties who wants the best of what both processes or options can offer.
One of the reasons to choose this UpMed Up is, as Vimin said, that the enforceability of the consent was finally. And also, in this line, the Japan is going to sign the Singapore Convention, which grants the enforceability for the mediation agreement in Japan. So in that sense, before more countries sign and join international convention, still respect for the meaning of the enforceability of the mediation agreement, UpMed Up proceeding is still useful. But in future, we may not need to think about the enforceability of the settlement agreement because thanks to the Singapore Convention, it's become easier to enforce the mediation agreement in anywhere in the country. But still, in practice, I think that the party may want to use the UpMed Up proceeding.
So that brings this session to a close. I would like to thank Biming, Tetsuo, Tepe for sharing their thoughts, giving an overview of resolving disputes arising out of cross-border transactions. For more insights into doing business in ASEAN, please check out the other episodes in this series.